only have one left, which is my handicap. That's it.
I'll rent one.
No, I'm good. I'm good. I'm ready to be done.
Shamrock shirt on for St. Patrick's Day already? Don't we all? Don't we all? So we're on section 5, which deals with practice issues related to injunctions. We don't have as many cases or other articles to look at this week, but we're going to focus on these cases pretty carefully. There was an advertisement in the Boston Globe that I pulled out from Sunday's paper. And it relates to some of the things we were talking about before. It's Own Your Own Business, Make More Money, the Franchise Expo. I had Dan scan it in and post it up. If you are interested, this, not this weekend, but the following, at Shriners Auditorium in Wilmington, February 23rd and 24th, is the Franchise Expo, and some of the franchises, there will be 7-Eleven, Something Beer, Bath Fitter, Lapels. You can meet with proven franchises plus the hottest new businesses and learn in free seminars how to start a business. Discover both full and part-time business available now. So some of your future clients will be getting into trouble in a couple of weeks at the Business and Franchise Opportunities Expo down in Wilmington. So if you have more interest in that, you might want to pursue that in a couple of weeks. But what we're going to focus on here are a couple rules. And specifically, Rule 52 becomes important. We talked about it when we saw it before, but I want to deal with it a little more in depth and a little better explanation for you, so that you have an understanding as to how it works when we look at findings of fact under Rule 52. In cases tried without a jury, and you know, we try a lot of cases without a jury, obviously. You know, it's not the classic trial you see on TV where you see the jurors in the box and everything else. But there's a lot of, certainly all probate matters obviously are tried without a jury. Any type of equitable relief matter that doesn't involve any other claim for monetary damages is tried without a jury. There are a number of times where you may choose, in order to have a hearing that is likely to be far sooner than a hearing before a jury would be, to waive the right of a jury trial. So over time, the fact is that you're likely to end up trying more cases without a jury than with. And so what you have to recognize then is that Rule 52 comes into play, because as you look in the first part of the Rule A1, it says, in general, in an action tried in the facts without a jury or with an advisory jury. Do you know what an advisory jury is? Other than what its name clearly implies. By that I mean, when would the court use an advisory jury? Yes, okay, but that's true, as an aid. When, though? Why would the court impanel an advisory jury? Anyone have any thoughts on that?
That's different than a grand jury.
It is. Grand jury is just simply indicting process. The advisory jury would be there, present throughout the trial. But why is the reference given to them as an advisory jury as opposed to a jury? A lot of times, we saw the 93A action. A lot of times, the court, the judge, may want to impanel what they call an advisory jury with those actions. Because in a 93A action, you're not entitled to a jury trial, but some judges simply feel more comfortable if there's a jury there to help determine the facts and the like. It's odd to me if you start to think about it, because, well, things could go a lot faster just simply with the judge. The plaintiff, if I'm the plaintiff, I would like an advisory jury at the minimum. And oftentimes when we try some of these cases that have a 93A action involved or that have requests for injunctive relief, the matters with respect to injunctive relief and 93A no right to a jury trial. But there may be other counts in that complaint, and oftentimes are, where we're seeking money damages for past wrongs or alternative theories of recovery that would go to a jury. And under those circumstances, the jury serves as an advisory jury on the non-jury counts, and then obviously a regular jury that will find the facts on the counts that are tried to a jury. And so in the same trial, they may serve two different functions as well.
They give like recommendations to the judge.
Well, in essence, yeah, it's not just recommendations. They'll come back with a verdict. Usually, that's what the court would ask them to do. But the court can reject it if they like, or can use it as a basis of forming their own opinion, and likely to do so. I mean, it seems it would be odd to impanel them when you don't need them at all, and then simply reject what they find. But technically, if it's solely an equitable matter, there is no right to a jury trial. And I have never seen a court impanel an advisory jury when it solely claims for equitable relief. I have seen them impanel juries where you've got a multi-count complaint that involves 93A as well as other relief, that the court will impanel an advisory jury on 93A claims, because there's a lot of fact-specific inquiry that oftentimes is helpful to have the jury weigh in on. But what this rule goes on to say is that the court must find facts specifically and state its conclusions of law separately. The findings, and we're going to see this in one of the early cases, may be stated on the record after the close of the evidence. So in essence, not written out, but just verbally, orally stated and recorded by way of either the stenographer or the tape. But what we're trying to do is create a record as for a basis for why the court did what it did. And so if it states its findings of fact and then states what its conclusions of law are, what the law says they must do based on those facts, the theory is they're more likely to get the ruling right than wrong, as opposed to simply saying, I find Ash wins, I'm going to give him the injunction for X, Y, or Z. If you have to figure out what the basis for getting to Y is, and you do it more methodically, A, it's likely to withstand scrutiny later on, and B, it's more likely to be the right decision because you put it forward in a process that should mean that there's a logical conclusion to what you found. And it's mandatory, as you see here, and that's good as well, because it allows for then the judgment to be challenged in the event that those findings are erroneous. In most trials, for instance, if you try a probate court case, a divorce case, or a will challenge or whatever, witnesses are called in, there's a stenographer that's present, the evidence is received, and then the trial is over. The rules tend to read like, well, at that point we submit our findings of fact and conclusions of law. I think if you haven't arranged for this in advance, you may submit proposed findings of fact and conclusions of law sort of as this is what I expected to prove. The more modern trend is for the court to tell you that they will expect you to file proposed findings of fact and conclusions of law, say within 30 days of the receipt of the transcripts. And what that means, and this is why it's more helpful to the court, is they expect you to get the transcript and the record, the evidence submitted, and then by specifically within the findings of fact, lay out where the support is for that in the evidentiary record. Parties were married on such and such a date in Boston, Massachusetts. Exhibit 1, the marriage certificate, right? So, and that's what those findings of fact and conclusions of law may end up being 50, 60 pages before you're done, all with references in the record to where those facts are. So it's not just your BSing through your memo anymore. It's actually a pretty labor-intensive process, because what you think you proved or got into the record, when you then go look at the testimony, it isn't always what you heard at the deposition or heard at trial. and you look and the language isn't quite as tight as you would like. And so that's why it's important as you're going through your trial, as you're going through this process, to make sure that you're establishing exactly what you think you're establishing. A lot of times, for instance, in the same vein, we take a deposition in discovery, we're pretty certain we're getting the answers that we think are helpful. When you read the written text of it, it's not quite as strong. Sometimes it's stronger. More often than not, you're surprised the other way, is that, oh, geez, I wish I went back for this next question and pinned it down a little better. And so sometimes you see the same thing in the trial, sometimes you don't. But I think it's important as you start to think about the transition with respect to findings and discovery and depositions and the like, we have to visualize more often what that answer, what that information looks like in text, as opposed to what I'm hearing. And if it's not as precise and as clear as you're going to need it to be to establish when the parties were married, or where the wife was or husband was when he first started stepping out, who he was with. If you want to establish those facts, oftentimes it means you need to slow it all down and make sure you put that information in the record if you intend to make those part of the basis for the decision. And so I think it's important that you start to think, because as trial lawyers and the like, we need to think like this. What is the written record going to look like? What is that stenographic record going to say as to what the question and the answer was? And that's really an acquired skill over time as well, but you have to start to think like that. And I think one way to start to think like that is, you know, if you're working in a law office or you're interning or whatever, really look at some of the depositions and start to see how the language will look like and how the question could have been better put or followed up on to get the more specific answer. Because, you know, if you think you've established that the plaintiff was constructively discharged on such and such a date by whatever the activities were, and now I need to go back into the record and find why I say that these facts rise to the level under the law of a constructive discharge, I need to make sure that it's pretty clear that he was effectively terminated on such and such a date. What would the facts, what facts would give rise to that, and where are they in the record? And sometimes they're here and here and here and here, and that's just tough luck. You've got to go into the record and get all the various references, because if you're trying to prove constructive discharge, if you don't have the facts to support it, you're in deep trouble. And so this whole process of findings of fact is labor intensive. The conclusions of law really are nothing more than what's the controlling law in this case. Broken down, though, really into basically a sentence at a time. And I often think, and I still don't do as much about it as I think I should, is that when a case first comes into your office, you do a lot of legal research. You've got to figure out what questions to ask, what information I need, what discovery I'm going to have to obtain to win here. We do a fair amount of legal research with the expectation that I'm trying to figure out what the controlling law is here so I can win. Obviously, then again, when we plead our complaints, the law becomes important even though we're pleading the facts, because I've got to plead the facts that will give rise to a violation of the law. I often think when I start to think about findings and the end of the trial, that what we really should do early on as well is look at what those findings of fact, or what the conclusions of law would look like, or what the jury instructions would look like in a jury trial. And we should do that at the beginning. We should be thinking from the very outset, the case is going to trial, and at trial, this is what the jury's going to hear. What facts do I need to prove, to pull in order to satisfy that law? And that's what conclusions of law are as well, is that if it was a jury trial, this is what the jury would be instructed the law is. But in essence, this is the controlling precedent in the case, and hopefully your facts are going to give rise to those violations of law that you said. And so again, you're assisting the court in some way with finding for you, and a good lawyer tries to make their findings of fact and conclusions of law so easy to follow and so readily clear that the court can then find on your behalf without struggling. And you'd be surprised that not everyone always does it. Sometimes the court will require it, but sometimes when people do it, they do a half-assed job because it's a lot of work. And again, as I've said in different contexts, if you're going to let someone outwork you, then that's your own fault, because there's no excuse for that. But these can take a lot of effort, and certainly a lot of effort to do it right, but it's virtually the last thing you're going to do in a case, and if you're not prepared to do that, then why did you put all this work in before this? And so that's the way you have to think about it. This is an aid for the judge to be able to find on my behalf. It's a requirement in most cases, and the court would almost always require it as well. And as we saw in the Pier 4 case, what the court ended up doing virtually is adopt all of the plaintiffs' requests for findings of fact and conclusions of law and reject the defendants. But that's simply because the plaintiff may well have been right. The plaintiff also made it relatively easy for the court to find for them in doing that. And so these become the last step as the court finds for you. And that's Rule 52. Rule 58 we're going to talk about on Thursday. But Rule 58 is just simply the requirement that the court separately set out what its judgment is, whether it's injunctive relief or for monetary relief. But that becomes important as well at some point, not just important from the standpoint of what is the court's order that I have to comply with, but also when we talk about the time running for appeals and things like that, a lot of that runs from Rule 58 is the separate entry of the judgment on a specific document, because sometimes the court will just enter its order on the side of the papers on the motion and the like, but the court still has to enter a separate judgment. Let's talk a little bit about Campbell Soup versus Giles, because there's a lot of things going on here that, I mean, I like this case, but it's a pretty straightforward employee-employer situation. The Campbell Soup brings an action against a former employee alleging breach of contract, misappropriation of trade secrets, unfair and deceptive trade practices. Pretty common, that's thrown around out there. Employee counterclaim alleging intentional interference with his contractual relations. And then we have United States District Court Magistrate Nathan Gort denying the request for preliminary injunction, and then there's an appeal. So first let me ask you, well, you know who Nathan Gorton's claim to fame is? Gorton's fisherman from Gloucester. You heard that? You heard those commercials, right? His family is, in fact, the Gorton's fisherman family. But that's not really why the case is here for you. So this guy is working for Campbell Soup, and he left to undertake civil employment at one of Campbell's chief competitors. They want a PI barring Giles from assuming his new position, at least through the end of the fiscal year, from otherwise making use of Campbell's trade secrets. And the Campbell now appeals complaining principally that the court erred in failing to conduct an evidentiary hearing prior to the rule. So I guess what I want you to start to focus on is the process itself. Obviously there's a complaint, and we look at the case and says there's a complaint, there's an answer, there's a counterclaim by Giles, and there's a request for injunctive relief, so that'll be a motion. In part of the complaint, obviously, there are prayers for relief or injunctive relief. There's an affidavit from Campbell saying why they need the injunction. So we've got the motion, we've got an affidavit attached to it, likely a memo in support of why they should get injunctive relief. And then the matter comes before the court, and so the question is, well, so now what is that process like? We've got clearly a hotly contested matter. How does the process itself of issuing an injunction work? Is it done on papers? Is there some form of evidentiary hearing, as Campbell suggests? How does it actually work in this process? It says the district court declined to grant the TRO and in a detailed decision denied Campbell's motion for a preliminary injunction based on its review of the documentary evidence. This seems to me like certainly Campbell's has significant power over Giles in this circumstance. And it says here he worked for them 13 years in a sales position, and then he resigned. It would seem like this would be potentially financially devastating to someone to leave their job, take a new one, and then be barred for, what, 6 months, 8 months, 9 months from working in for their new employer. Seems like a pretty harsh request, no?
Never mentioned that he didn't sign a non-compete clause.
Well, tell me about that. So, what is a non-compete clause?
This company forbids you from working for another company that's a competitor.
Well, is that true? The company forbids you from working for another competitor, or we agree you won't work for another competitor?
Right, it's agreement.
Well, no, it is, right? A non-compete is an agreement. So we agreed that you won't work for a competitor. What are you looking like that for?
I think that sometimes it's kind of, it can be sort of unconscionable at times.
Well, why did you agree then?
No, but it is. I mean.
But it is
it's
what?
an agreement, yes, but I think that they can be unconscionable.
But it's not forever, it's for a certain amount of time in a certain jurisdiction, but you could still work.
Well, like, would a year be unfair?
Yeah.
Oh, would?
I have 3
Yeah,
for mine.
that's,
No,
yeah.
3 years in yours.
Out of work for a year,
Like
yeah, that's
150
fine.
miles.
3, Patrick says he is aware of one that contains 3 years, no competing company within 150 miles, 2.5-hour drive. 3 years.
Well, that's much.
That's a long time.
You're giving up something, so, you know, you should be getting something in return.
Well, when you say you're getting something in return, you're getting paid your wages, right? You want to work for me, here's the deal.
Right, right.
So we agree you won't work for a competing, in a competing business east of the Mississippi for a period of 18 months. That's non-compete, right? Could that be enforced?
State.
How do you evaluate whether they're enforceable or not?
Whether they're reasonable.
Reasonable. And reasonable what? Right? Is that some test? Like reasonable in time, scope,
I guess you would look at
duration?
how much of a conflict.
Okay, but I don't. Shouldn't you be telling me all these things? Well, no, seriously, isn't there a test? Isn't there? What?
How much of a conflict does it become? Are you if you go to work for, okay, so he's with Campbell's in their marketing department. Now he's going to go work for Progresso. Is he also in the marketing department? Yeah, but what if he was?
Well, could I say you're a soup guy, Pat? No. You can't work for a competing soup company for the next year. Could that be okay?
I think it's.
Because if you're Campbell's, aren't they all competing with Campbell's? So I can shut you out of the soup business, but you can go find other business. Is that? Well, that's.
I don't think that's unreasonable.
You don't think that's unreasonable?
If you're in the marketing, you know, if marketing people can switch industries, so, I mean, being so confined to a soup company, I don't think that's unreasonable at all.
So I just don't want you to work for a soup company, or an office supply company, or another beer distributor, whatever it is. Medical sales. But that's my business, right? That's what I do. But that's your choice. If you want So we can, because it's not a free negotiation truly, is there? I mean, they talk about that, but listen, you want the job, Patrick, this is what you're gonna sign, and this is the deal. Well, how about 100 miles? No, 150. How about we narrow it down to this or that? No, 150, this is it. I'll give you a little kicker, I'll give you another $5 grand a year. No. I'm in? Well, go ahead.
I'm against them from a business perspective for a lot of reasons, but from a legal reason, I'm thinking if there's, if you don't have an equal bargaining power, you've got a contract
We've never
that's,
done
right, so it's, then if it's not unconscionable, then you don't have proper consideration for the contract. If you have to have the job.
Well, we all have to have a job,
So
but we're not
it's-
being.
Yeah, so it's an unfair bargaining power, that's for sure.
But that doesn't seem to matter, does it?
I think the more restrictive the non-compete clause is, the,
More restrictive with respect to both geographic area and time,
the more that it won't be
And scope.
enforced.
the more it won't be enforced. But about 150 miles? That's actually not that bad. Seriously, I'm not kidding. I had one, it was east of the Mississippi, and it was in a very broad area. You said, oh, we should be able to do something here. But it's kind of a specialized field, and there's like, you know, 3 main people you might work for in that industry, and
To both their points, there was, he's right, it does depend on who the person is, because I had an employee that got his non-compete thrown out. And me, as one of the owners of the company, when we were doing this whole deal, I didn't have any flex room. They're like, look, we're buying your company, this is what we're doing. I
Right.
don't want you to go open up shop. Once you get all of our info, because you have, you know, history of having a company, now you're gonna come in and be on the inside. No, you're not gonna go up. But then my employee, he got thrown out altogether.
by a court or just
No, just
negotiate?
negotiating, because he said, I'll go somewhere else.
Well, would you guys put these in your business agreements? I mean, you're lawyers, right? So I'm gonna ask you when I'm buying the business. I'm gonna tell you seriously, up to North Conway, coffee shop my daughter loves is called The Met. People spent a lot of money buying it. It's kind of a neat place. Honest to God, they didn't own it 2 months. And it's not even 50 yards. It's diagonally across the street, another coffee shop. I think it's by the people that sold them The Met. And it seems like, geez, this is not what anyone had in mind here. If you
The
didn't
wine
sell-
shop should have stayed there.
Oh, you know what I'm talking about? Yeah, that's right. Well, you know, really, because they'd hurt them.
Oh, absolutely. I mean, you could throw a rock from one.
Yeah, seriously, they're not, what do you think, 25 yards max?
It's just literally across a 2-lane street.
It's across a 2-lane street. And
It's very
and they were the only coffee shop before, and now they've got a serious competitor. And I really do think that in part, and I'm not sure this is true, so I'm just saying, but assume it was the prior owner. If I'm the owner, the new owner of the Met, then I'm gonna be saying to you guys, I'm coming back to my lawyer and say, what the hell? You didn't put this clause in the agreement? I'm now gonna pay a premium for the location, but immediately across the street, I'm getting killed. So would you put those agreements in? Because you guys all sound like you think they're a little unfair. But you sound like they're unfair when you're representing the person restricted. Because go ahead.
Yeah, I think that's state law. I think when I was.
What's state law?
Well, non-competes, I believe, are state level, because.
Well, they're
Massachusetts-
going to be controlled at the end of the day by determination of what state law permits.
Contract law, whatever. And I know New Hampshire, and I know that's actually very common in New Hampshire, so if you're a lawyer and you wrote up a contract to buy a business and you didn't put a clause in there, it says you don't open up within, it's so
So
common.
many
in the
miles
retail-
or so long, no?
In the retail industry, that is so common for a seller to go and sell his business and open up the same thing down the street. It happens all the time.
Yeah,
It's
but
crazy.
I am paying a premium for that. I don't want you to all of a sudden run me out of business when I just paid a premium. Did Giles, we started with that, I say, Giles didn't have one of these non-competes?
No.
Any type of confidentiality agreement or trade secret
Yeah,
information?
he had one of
Yeah,
those,
that,
yeah.
Okay, but he didn't have a non-compete.
Not- not-
And obviously with the non-compete, we would be able to see what the terms were what the duration was, to what extent it allowed him to work elsewhere during that period. But I do worry, though, as a general matter, in the new manner in which we do business, that you could restrict an individual by way of a non-compete. I mean, I'm wondering how you would interpret the geographic limitation today when a lot of business is done by way of the web. I mean, could I say you can't do business on the web? Can I? I can't. So if your customers and your new company are coming to patsproducts.com within that 150-mile radius, does that violate the terms of a non-compete or not?
Maybe, but I can sit in my home within that 150 miles and sell to people outside the 150.
But if those 150, if some of your customers are within the 150, it's a violation,
Could be.
right?
Could be.
Even if you're in Bermuda, because things are going so well, you could potentially violate. Well, I don't know how you're going to phrase it, but I just think you need to start to think about it. But so you guys are saying he's not subject to a non-compete, but he does have confidentiality / trade secret.
Most of the marketing
Good.
information was no longer confidential.
Well, let's talk about that. So he's in marketing. Did you know there was a soup season? It makes sense, right? That's just what I said. When I said, well, it makes sense. Who the hell eats soup in July? But there is a soup season, and obviously that's important to know, because really they're trying to lock him out for another 6 months. Would you bring one of these actions on behalf of your client as a means of discouraging that person from either taking the position or working for them? Because this is what I'm thinking, and I think we're going to see one a little down the road. I mean, if I'm Campbell Soup, I get tons of money. Ash doesn't. And if I can lock them up, make them think twice, slow them down, all I need is 6 months here. Crap, I got enough lawyers I can tie in the knots for 6 months. And you know what? You really can't afford it. Could any of you really afford not to work for 6 months and still pay your bills and all the rest of it? So I could see where these would be used for business, tactical advantages, and you being my agent for that, right? Because I would almost think that from a business standpoint, I shouldn't be doing this, period. I got Pat who leads, I don't care if he's got an agreement or not. I'm going to try and keep him out of business for a certain period of time, restrict what he can do. And if I'm the company, I'm not sure I'm buying into it, ponying up 10 or 20 or 30 grand just to sort of free up this employee either. So it's Pat's personal money that he's risking. This sounds like I could use my superior position and assets to really.
Sounds unethical.
Does it?
Yeah.
So, what do you weigh when Campbell Soup comes to you and says, I'd like you to be my new counsel in the Massachusetts area? We're trying to make sure that some of these employees don't leave. Or if they leave, we don't want them. We don't want people leaving our company, going to work for a competitor, and injuring us. That's not good for our business. So,
I would tell them that they should probably think about confidential information that a part of an employee may possess before filing a trade secret claim.
well, would you have filed this one? Because he didn't have a non-compete. He did have an agreement and was exposed to some trade secret information, right? Marketing plans, at least for some period of time, might well fall within a secret or confidential relationship. Trade secret, I don't think it's quite the formula to Coca-Cola.
Right, it was a confidentiality agreement. And also, I think the big one was the pricing. He had the wholesale, the cost pricing. So that was a big product.
I think that had
But
already
that was released.
been launched.
No,
Yeah.
not cost pricing, not Campbell Soup's cost to make a can of soup. That was not public information.
But there was no evidence to show that he had already, that he had divulged that either.
Right.
So.
No, that's not, you're correct, but that was the good reason to have a confidentiality agreement, though, is to keep, there was certain information they didn't want out in the public that he had.
I kind of got the impression this case was a bit personal
Yeah.
with this guy.
They were
Well,
upset.
don't you think a lot of them are gonna be? All of a sudden, I built you up, I've educated you, and now you leave to go work for my direct competitor. I think a lot of times it might be personal. I'm still surprised that my brother, when he left, wasn't sued by his boss, because the business he and his other partners established was in direct competition with the company. He didn't have a non-compete, he refused to have signed the non-compete. But, you know, when you're starting a business and your resources are limited, I'm surprised, frankly, for tactical advantage, it wasn't brought just to try and muck up the works. Isn't it personal? So I've educated you for 10 or 15 years. Now you're taking that, you know, after your post-grad was on my dime. Now that you're paying, now that you're able to pay that back, you're going to go to my direct competitor and use that valuable education I gave you. So I think it is. Sunshine's not personal?
No, because he was faithful to you for those 13 years, so you both had an agreement and there was consideration on both sides, so I don't see it that way.
But you're going to work for Progressive.
I am, but I gave you 13 years. So in that whole 13 years, I took my education on your dime. I
So why
didn't
don't you
give
go
you
work
any
for Papa
service.
John's? Fine. Work for Progressive.
That's all we know.
Well, but that's all you know, because that's what I educated you in.
Yeah, but I gave you something back. I gave you my service for 13 years, so it's not like you just gave me education.
And this is how you pay me back. You cut my throat.
No, you don't.
Right? And because the question is it personal? You don't think it is?
It definitely is. This guy was an area, it's not like he was working on the assembly line. He was an area director. He was one of the higher ups in the company.
But not that high up to have a non-compete. Right? I mean, because that's his side. Is if I was this valuable, as you now allege, where's the non-compete? Where's the premium to my salary for all these years that you paid for that I knew, okay, I'm that valuable? Because, so, would you have told Progressive Kimball's? No. This is, you don't have a non-compete, can't do it. I think it is personal. I think, and by the way, this is the thing, and this is why I think you guys have to really think about it. And I don't know where it ends up. But for a guy to defend a suit like this, guys, in federal court, he's got to give me a check for 10 grand, doesn't he? I mean, seriously, because you know they're seeking injunctive relief. This hits hard and fast, and I'm looking at piling hours up very quickly, right? 10 grand, 30 hours at $300 an hour, 33 hours. Gone. Really, 10 grand. 10 grand is not going to do this because we're going to be running back into court on the TRO and the prelim. We're going to go through, in short order, 50 hours. I'd be surprised if it's not. That's almost a given. Remember, TROs, they happen, everything with injunctive relief happens at virtual breakneck speed. Right? They come in and lay all this paperwork on me. Now I got to do my research. I get my affidavits ready. I got to submit that with a memo to court opposing all of it, asking for some form of hearing, just trying to catch up. And so that means I got a lot of hours really quickly. How many employees who are changing jobs and all the rest of it have that type of extra cash laying around? I mean, from a business perspective, it seems like a pretty good business move, even if it's kind of slimy ethically, no? Go ahead.
I've actually lived this, but anyways, separate from that, the balancing between the two companies, the leaving company and the getting company, depending on the industry, this industry might be different, but in the high-tech industry, it's not worth it. It's not worth either side pursuing it. Either, like from your perspective, a business, go after the guy and stop him from getting a job, it's not worth anything. It's not worth that much. Even if he goes to a direct competitor, you also got to understand the direct competitor is not allowed to take that trade information that's that's protected, whether it's a trade secret or whether it's a trademark.
Don't they steal stuff all the time from each other?
Yeah, but it's not that valuable most of the time. It's not, and you can't get caught using it anyways because you'll get sued by the other manufacturer too. So there's so many. That's the counter argument to what you're saying. In other words, you would think it would make sense to stop the guy, but it's just not worth it. You know.
Well, why do you say it's not worth it?
Because I got to pay my lawyers $300 an hour to go pursue that case.
On Campbell soup, crap. What's 15 grand to me? 20 grand, 25 grand to me. Campbell soup. Campbell soup. And soup season. But 25 grand to an individual who's faced with this is maybe overwhelming. And there is I mean, we can look for equal bargaining power. The court doesn't care because there isn't going to be there. The question is, was it arrived at, and is it reasonable in scope and duration and geography, right? What does it do? And I worry that as the zone of business expands, this whole notion of what's reasonable expands, and okay, you can't work in the soup industry, you got to go find some other food industry. But that's all I know. So he didn't have the non-compete. He was exposed to some level of trade secrets. Campbell's nonetheless says we want him to be prohibited from working for them for 6 months, a year. Really, in essence, till the end of soup season is what they're saying, right? So they're not asking, how long did you say? Did you say 3 years?
That's a long one.
That seems long, right? But, so they're not asking for a period where we would say, holy schmoly. Not that I haven't seen 3 years either, by the way. I've seen 2, I've seen 3.
That's 2 or 3.
Yeah, and you say, wow, because that really means, well, it does. And listen, from an employer standpoint, whatever I've taught you, if you're out 2 years, certainly, in a lot of business climates today, you might as well be starting all over again, right?
Are you a founder or something? Because that doesn't.
He's a big deal.
I've never seen 3 years. I was going to say,
I was a partner in the business that got purchased.
Okay, yeah.
And they don't want him opening up the coffee shop across the street.
Yeah.
Mm-hmm. Go ahead.
But Giles was a salesperson.
Right.
Giles is not the guy making the ingredients for the soup.
Yeah, but
isn't
my salesperson? He's my face out there, right? He knows the customer. He's got the connections.
I think they want to stop him from going after those customers that he's built up.
No
but
doubt.
I can't see why, as my colleague said, why would they go so vigorously after him when he was just a sales rep?
Well,
I think that would be a waste of finances, resources.
But listen, not only did they go after him, but they took an appeal from the initial order denying their ability to get the injunction. I mean, they didn't just walk away when they were discouraged originally. They kept piling money into this, and Giles did too. Let's just look at it. So they filed this request, and there is, as you guys already debated, maybe the project's a trade secret, but the marketing information really wasn't confidential because at this point there was some public disclosures about that. And obviously he did have customer base, knowledge about that. And that does appear to me to be what they were trying to limit his ability to do somehow, is to really provide them information that would give them a marketing edge or an ability to sort of counter Campbell's new plan for their special soup. What it says in Roman numeral 2, that the district court properly enunciated the test governing the award of preliminary injunction. Now they used the remaining 4, but I want to add, which is pretty common, the first part, which is always whether you get equitable relief at all, is that there's no adequate remedy at law. And what that really means is that money damages won't satisfy what the plaintiff's claims are here. But then they go on to say the test is, and it's the balance of the 5-part test, the movement's likelihood of success and the merits, the potential for irreparable harm or injury, a balancing of the relevant equities, and I refer to that as a balancing of the relevant harms. And it doesn't make a difference which way you want to look at it. And what would be my fifth part, they show it as 4 here because they don't show what I think is the 1, is the effect on the public interest, which I don't see how we can turn, you know, a business dispute about soup into really having much effect on the business interest here at all. And so Campbell's doesn't really dispute that the court at least enunciated the right part of the test. What they're saying is we don't think the process was appropriate here because we expected some form of evidentiary hearing. Campbell's, it says, nor does Campbell dispute the district court properly applied Massachusetts trade secret law. And if you look at this, by the way, this is important to understand, it's in note 4. Massachusetts has some pretty broad protections for trade secrets. There are privileges. There is a privilege for trade secrets that we have in Mass, and we don't even have a documentation privilege in Mass. So things that can classify, even as broadly as this, as trade secrets, Massachusetts law will strongly protect. And it is oftentimes in pieces of litigation where we will get orders in litigation where if it can be construed as trade secret information, we can restrict the rights of people to get access to it, even within the law firm, who can get access. I've had motions made where they don't even want my client to get access to what they're calling trade secret information. And obviously, it's the client who can make more sense of it, certainly, than virtually anyone else. But you'd be surprised, there's case law out there that absent a confidentiality agreement during the civil litigation, where the court will restrict people's right to access what they see as trade secret information. And obviously there are some companies like Campbell Soup here that want to call virtually everything trade secret, and when you look at it, none of it's trade secret, but what they're trying to do is prevent others from getting access to the information. And they also want to try and get some of the records sealed. So for instance, the affidavits, the memorandum that's submitted for the injunctive relief and the like, that no one can see that either. In part, I find more often than not, they're trying to hide the bad things they did than truly try to protect trade secret information. But there's some real ability under Mass law to argue that trade secret information can be construed very broadly and that the Massachusetts courts will protect it broadly. But let's talk about this evidentiary hearing. That's what Campbell Soup is saying here. Is okay, yes, we filed our papers. Yes, they filed opposing papers. And then the court simply rules on the request, and we never got an evidentiary hearing. An evidentiary hearing, as you know, is where the parties and their witnesses come into court. The witnesses are sworn in, and there is testimony taken both from the standpoint of direct exams as well as the opportunity to challenge that testimony by cross-examination. It's the typical type of hearing we see on in TV. And what Campbell's is saying here is, we don't believe what he said. We don't believe that he hasn't been using this information. We want Ash to be put on the stand. We want him sworn in, and we want the chance to examine him under oath. Because think of what the process is up to now. It's the complaint written by the lawyer, right? It's the motion written by the lawyer. It's the affidavit written by the lawyer but signed by the client. And it's a memorandum written by the lawyer. You'd be surprised, well, you would be surprised. Since all of that is so heavily influenced by the lawyer, the likelihood is you have slanted the description of the facts and the information in there, both by the way in which you've said certain things and the omission of other things, that we're not getting the full version of the events. Do we agree on that? Is that what you did? Do you agree you did that?
Well, but that's what happens.
What do you mean that's what happens? Because that's what happens, like other people have done it. I asked you, is that what you did? Is that what people pay us to do?
To color the facts.
And color the facts. You know that's an expression I use because I find it acceptable, but we know what that means, right? I mean, you have slanted the facts to advocate on behalf of your client's position. And by the way in which you've said certain things and the omission of other things that are harmful, you have not presented a full, the full information to the court, right? Most favorable to the client, which means obviously omitting some things and painting things in their best possible light.
Yes.
That's what we do.
Right.
There's nothing wrong with that, right?
That's what we do.
That's what you're taught. No, I just want to make sure, right? That is what we do, isn't it?
Yes.
As long as it's not frivolous, because you gotta sign it.
Well, you're signing the complaint, but the client signs the affidavit, you sign the memo, you sign the other things, and no one has a problem with that, because that's what we do, right? We are, right? We are.
I just know there's a snag coming.
No, it's not a snag coming. You seem to hesitate at first because it does sound a little sleazy, doesn't it?
Yeah.
You have omitted certain facts that if the court was made aware of, that would place your client in a bad light.
Well, the other side is gonna.
Well, so they're gonna cheat too.
They're gonna cheat.
So that's okay. So as long as you're both playing by the same rules, there's nothing wrong with it.
We're both coloring, it's a matter of somebody staying within the line.
I like the expression coloring too, but you're painting your colors paint a distorted picture of the world, don't they? I mean, I do too, right? Because that's what we're advocates. We put it in the best possible light. But the court, by way of both our words, hasn't gotten the full picture at this point, have they? They've gotten what I say is my version of the facts. They've gotten Ash's version. They've got affidavits that I wrote. By the way, I want to be 110% clear on this. You always, when you give them that affidavit, you've got to make them sit down and read the entire thing and tell them that they cannot, should not sign it unless it's entirely accurate. Okay? Because they're signing it on the pains and penalties of perjury. And the fact is, and I've said this to you guys before in other contexts, the first person, when the spit hits the fan, they're going to roll over on and throw under the bus is you. You say, no, he or she said I had to sign it right away, I couldn't make any changes, and no, I told them paragraph 2, 3, 4 are wrong, but they said sign it anyway. You're the one under the bus. So if you're not going to do the honest thing because it's honest to do it because you're the first person under the bus. And so ever since I've been a lawyer, I mean, I have a routine and a practice on the affidavit, and I don't care whether they're in a rush or not. If they're going to sit there, I'm going to leave, and I'll come back. But I want to know that you've had the opportunity to read it, that you're prepared to say it's truthful, and I'm going to start our explanation with do not sign it unless it is entirely truthful. And you've got to have sort of those practices in place so that you can say, after practicing law for 30 years, that that's what I do, because that's what I've always done. And trust me, you know, over the course of that time, if people say, well, Mike, if you wrote it, it must be true. Oh, that's not the way it works. You sit down and read it. No, if you wrote it, it's right. No. It's not what I say, it's what you say. Okay, I want to make sure that we have it exactly the way we talked about, and you've got to make sure that that's accurate, or otherwise, I've taken affidavits, and I have shoved it down the other side's throat, piece by piece, sentence by sentence. And it's devastating if they've signed affidavits under the pains and penalties of perjury and it wasn't true, because now they are a liar, okay? So by trying to reach and get a little more, if that wasn't accurate, and I can prove it's not accurate, then now I'm gonna win because you're a liar. And so it's also for your own purposes. You wanna make sure it's accurate and defensible because you know, your memo is a memo. Okay, shades of gray. You've done enough of those over time. Your motion is pretty clear as to what it is. Your complaint are allegations as to what you say is true. Affidavits someone's signing under the penalty of perjury, and it's your client. And if something hits the fan, they're gonna throw you under the bus on that.
Would it be advisable to have your client sign like a disclaimer, like kind of like a Miranda waiver, where you have the the arrestee sign off that they've been read it, that you've advised?
It's probably not a bad idea. It doesn't create a lot of trust between us, right?
True. Yeah.
So.
Are you still a liar if you just can't recall the events of what you signed?
Sandy, what was that face over there for?
Yeah, of course. Because, I mean, what do you mean, if you're going to lie in the affidavit and then
Bill
also
Clinton.
remember?
No. Now he doesn't remember about what he signed. Or he doesn't remember whether it was true or not.
Come on.
Thought it was important, he knew it was in the penalty
Yeah.
of perjury, it wasn't that long ago, and now you don't remember any of it. I mean, right, it's.
Not any of it, but portions of
The
it.
potion said it bad. I mean, there's a ways to attack that as well. But let me, so, there's an expression that we say, we obviously do paint it in the best possible light. But sometimes you might want to give them a little of the bad things, because if they've got it anyway, you know what I mean? If they've got it anyway, what the hell, throw it in. Because then it makes the stuff I tell you look even more true if I'm giving you some bad. In essence, I'm giving them the sleeves off my vest. I'm giving them something I don't need anyway, and you know what, they got it anyway. So if I know I'm not working with a written contract, maybe I say, we never had a written agreement, but we had this. So maybe some of it you throw in, it's not the best possible light, but it is what it is. It's the truth. And I don't have to slant them so much that I lose credibility either, right? I mean, you are an officer of the court, you do have some obligation to disclose certain information, and you may want to think about that aspect of it as we paint it in the best possible light. The other thing you better think about too is maybe there will be an evidentiary hearing, and you don't want to look that bad if you've overstated your case, because again, think about what it means. This is the first hearing we're going in on. In federal court, that judge is going to have this case from now till the case is over. I'm starting here. Either I can go up in the judge's mind, or I can go down. And better to do it right, better to potentially lose the battle and win the war, but better not to sacrifice your credibility and your professionalism because the court doesn't think that, the court thinks you're sleazy or that you've overpainted it. A lot of times you're going to be back before that judge, and especially in federal court, you're going to be back before that judge. There's a lot to be said for being forthright, being honest about your case and its strengths, and obviously we minimize the weaknesses, but you can't make like they don't exist either, because there is a real balance there between overstating your case so that it's clearly not truthful, because that'll cost you in the long run as well. But okay, so we've got a record here. You guys are conceding both sides are not entirely accurate in their version of the events. But that's the process we work in, Ms. Kelly tells me. Why doesn't Campbell get the hearing then? Why can't we have the witnesses sworn in? Because I will guarantee you one thing. Their testimony will not be as strong as that affidavit. Just can't. Whoa. Because I know you wrote the affidavit. You did, right? That's your job. So wouldn't a better process to get us closer to the truth being that before an injunction issues, there should be an evidentiary hearing? Because that's what we're trying to figure out is, do I get an evidentiary hearing, and if so, under what circumstances for that request for injunctive relief? Because Campbell says, I want an evidentiary hearing. Go ahead. Frankly, if I'm opposing an injunction, I want an evidentiary hearing. Right? This is the other part of it. Plaintiff wants it. They've got the burden of proof. What the hell? I'll have some fun. Right? Swear them up, put them on the stand, let's see what I get. Worst case, I get some free discovery coming, right? Right, because that's what it is here now. I'm going to get sworn testimony under oath, I'm going to get access to some information, and I'm going to get a big jump start on this case. What the hell, if I'm the defendant, I think I want the evidentiary hearing even more than the plaintiff does. I definitely do, because I don't have the burden. Swear them up, let's go. Sounds like a fun afternoon, right? So Campbell says, what the heck? So under what circumstances would Campbell get a sharp, under what circumstances would Campbell get an evidentiary hearing? And by the way, we're going to see that this standard is not the same throughout the circuits. This case happens to be in the First Circuit, which is where we are here in Boston. And there will be some variation among the procedural requirements as we look at a couple of the different circuits. So under what circumstances does Campbell get, well, first of all, was the court correct here that Campbell didn't need an evidentiary hearing under the circumstances?
I agree with it.
They did not.
Right.
Okay, and the court was correct in saying Campbell doesn't get an evidentiary hearing under the circumstances of this case, right? So now we have one rule. You do not get an evidentiary hearing in all circumstances when one requests injunctive relief. Certainly not, and I think that's fair to say generally. So, okay, we've got one rule. Under what circumstances do I get an evidentiary hearing when one seeks injunctive relief?
Dispute of facts.
Yeah, the facts are.
Is that it all that just as a dispute of facts? Because there's almost always going to be some dispute.
Material facts, maybe?
Clear abuse of discretion.
Well, it's clear abuse of discretion, but that's only, we're going to know that after the fact, whether the judge has abused the discretion in granting or denying injunctive relief. Gary, what do you got?
So it's probably the second page of section 2, the top of 261. It says the pertinent factual events are in sharp dispute.
I think that is the correct language here that we're trying to focus in on. It says, to be sure when the parties' competing version of the pertinent factual events are in sharp dispute, such that the propriety of injunctive relief hinges on determinations of credibility, the inappropriateness of proceeding on affidavits alone attains its maximum.
So they want to see faces in a courtroom, I think, in that point. Credibility is the key word there.
Exactly. And credibility, and then so there's two important parts to this test then. Sharp dispute, right? That there is a significant and sharp dispute between the parties' version of the events. And that the credibility of the witnesses is at its most questionable. Credibility is almost always, for the finder of fact, an in-person question. You know, we use an argument on credibility as the reason why we need the trial itself, a jury trial in a case, and especially when we're talking about requests for injunctive relief. If we can make an argument that it turns on the credibility of the witnesses, such that the court should personally see those witnesses and take testimony from them under oath to gauge their credibility, there's a much greater argument as to why we should be getting an evidentiary hearing. If you're simply arguing you want an evidentiary hearing because that's what you want, and you can't show that there is in fact this sharp factual dispute, or that the credibility of the witnesses isn't key to whether their testimony is in fact accurate or not, then the fact is we can determine on papers, as well as anything else, whether you should win or lose. A lot of cases it's relatively easy. But if you're saying that, no, you know, Pat says the situation is A, the defendant says the situation is B, one of them is clearly not truthful with respect to their version of the events here, well, that's a sharp dispute with respect to the facts where the credibility of one of the witnesses is telling the truth and one is not telling the truth. That's the perfect example of where the court should entertain the request for injunctive relief being by way of an evidentiary hearing, because that's what the courts do to determine credibility. They bring the witnesses in, they swear them up, and they view them in person to determine whether they're credible. The fact is, you told me the other night that you don't think lawyers should take cases without seeing someone, even if it's by way of Skype, and sizing them up as you look at them. why shouldn't the same be true when it's an evidentiary hearing here? One of the reasons it shouldn't be true, by the way, is time, right? Even a short hearing would say 2 witnesses on a request for injunctive relief. That's an afternoon's worth of work, right? That really is, that's after having read the papers and everything else. Where if I read the papers, I weigh it, I look at the memos, allow it tonight, I'm done. There's no reason for another couple hours entertained with the sort of the show you guys want to put on with the direct and cross-examination and playing lawyers. Obviously, you get paid to do that, and that's what you should do. But the fact is, the court would prefer to do its business without us a lot of times, and that's in part what they're saying here, is the court's got a crush of work. If there's not this sharp dispute, credibility isn't an issue, then Campbell shouldn't be, is not entitled to injunctive, is not entitled to an evidentiary hearing. What they say here is over the course of 18 days, you know, see, again, this is the court justifying its own actions. When we talk about lawyers coloring the facts, over the course of 18 days, Campbell submitted an abundance of material, a verified complaint, 3 initial affidavits, a total of 7 reply affidavits on 2 successive occasions, a legal memo, 4 letter briefs, excerpts, it does sound like a lot, excerpts from the treaties, and copies of pertinent case law. Over the course of 18 days, like 18 days, they just keep loading the wheelbarrow up and dumping it on the court. Obviously, there was a period of time where they submitted information. The notion that they were submitting information every day, as that seems to indicate, and as all of this material seen, and it is frankly, that is a lot of material. To now, for Campbell to say, well, we never got heard, and again, they did get heard because it wasn't just on papers, but then there was what we would call a motion session where we argued before the court as to why we should get what we're looking for. Campbell's was heard. They don't like the answer, but the fact is, this is not one that doesn't look to me either, that the court just sort of on a perfunctory basis said, admit or deny. You know, it just reminds me, where were we? Were you with me when we saw the 8 ball on the judge's bench?
No.
I swear to God, I've got a picture of it from one of my travels. Might have been San Francisco, in federal court or one of the courts, and you looked up to see what was there, because, you know, we're there nights and weekends doing this. And you looked up and I swear I've got a picture of it somewhere. There's an 8 ball on the judge's bench. You're thinking, so this is the way. That's the way. Injunction granted. Someone obviously had a sense of humor. I've got a picture of it somewhere because I said, well, I'll take a picture of this. You hope that there's a better basis than that. But Campbell's, at the end of the day, on this case, didn't get short-handed. And now let's just look, I want to go to the end of it, because there's a couple things here I think that are important as well to think about. It says, and we're going to read this AU case, which is an interesting case, shortly as well, which is referenced in this a couple times. Even where Rule 65 fact-finding is desirable, it is designed to be tentative, preliminary in nature. The web of conclusions upon which a PI rests are statements as to probable outcomes, nothing more. It's nice language, it's important to remember. The fact is, you can lose your request for a TRO or preliminary injunction and still win the case. Oftentimes the problem is if it's granted, that all takes on a life of its own as well. And so the party who has the injunction has likely some tactical advantage in winning that early, that it may help generate favorable settlement talks. But there should be, as it says here, findings of fact at some point, but at the preliminary injunction stage, there are only probabilities of what the necessary facts will be able to be proved at trial sometime down the road. And so the fact is that may well come significantly later. And at the beginning stage of the case, the court is really trying to make its best guesstimate on the likelihood of success, on the best estimate as to what evidence is likely to be obtained in the process that supports one side or the other. And remember, that's the other part of this, is none of that discovery likely has taken place yet. So the situation can change significantly, but it can also mean that it becomes a crucial event in the case. Frankly, if they had obtained the injunction over Giles, the likelihood is he would have been forced economically to try and resolve this more quickly, simply because he probably couldn't afford to be out of work 6 months. The fact is, losing this year, I don't see, and I think the court, the facts indicate, I don't think they were likely to suffer anything significantly by the denial of injunctive relief. But I do find it interesting how hard they fought it for what would seem like a relatively mid-level at best employee. But obviously they thought they had much more to gain by way of obtaining the injunction than not. I want to talk quickly about the impoundment. I mean, this hardly seems like a trade secret case. It hardly seems like a case warranting the impoundment of papers. But nonetheless, they were impounded. I find this a lot in business litigation, that what the defendants want to do is keep their misdeed secret. And they want to impound the papers so people can't get access to them. First Amendment, and the way the structure of our court system is it means that the public should have a right of access to this information, and it should be available for them to be able to examine and see and have trust in our the judicial process as well. I do find too easily that parties will agree to confidentiality agreements during the course of the litigation and allow too many papers to be impounded. And I don't think the court should be as easy as they were here in granting that information. Massachusetts state courts are a little more restrictive. But the same thing applies in our mass cases, where there will be times where your client or the parties may want to restrict access to this information by way of impounding the papers. So whatever papers are filed, people can't get access to. And I think you've got to weigh that carefully, because I think the public has a right of access. I also think, while you don't represent the public, it isn't necessarily in your interest. Certainly representing the plaintiff, sometimes it is. More often representing the defendant, it's in their interest to keep their misdeeds, to make them more secretive, because I do think sometimes companies, I think there is something unfair about what Campbell's was trying to do here from a business standpoint as to a mid-level employee. And in part, they may want to have kept what they were doing secret. Obviously, they did have some information about their new product line that they were worried about. I think I'd be very careful about simply agreeing with the other side's claims that the documents and all the information needs to be impounded because it's confidential company information, because I've seen it used way too often where there's no real confidential information involved. They just don't want people knowing what they've done. And obviously there will be some cases where you have confidential information and you may enter into these agreements. You want to carefully, as the lawyer, make sure that you can still prepare your case and get the necessary assistance on it with respect to who can access that information if you're going to treat the information discovered confidentially and impound some of the papers. So there's a lot going on in this case, and I think it's an interesting case, but it's also focused on that procedure there, because this is the process that we're going to have to look at as we go through some of these cases. Is not just the merits of the situation, but how does it mechanically work? And what we know right now is you don't get, you're not entitled to an evidentiary hearing. You may be more likely to get it if there's a sharp dispute, factual dispute, where the credibility of the witnesses is key to the determination of the case. See you next time. What time, 8? Or 9?
Nah.
Sir, what's going on?
It was mine.